This video will cover the Supreme Court. This will cover the following topics within the US Supreme Court. We will be looking at the structure of federal courts, membership of the Supreme Courts, the appointment and confirmation process, the power of judicial review, judicial activism and judicial restraint, the Supreme Court and the Bill of Rights, public policy, congressional power and presidential power. We will also be comparing the UK and the US Supreme Court. All of these topics will be broken down into individual videos. Part of the Supreme Court unit is also to look at the civil rights of America. However, this is going to be covered in a separate video. This video is going to focus on the structure of federal courts as well as the membership of the Supreme Court. The judicial branch of government is the system of courts that interpret and apply the nation's laws. The Supreme Court is the highest court in the federal judiciary and acts as the final court of appeal. According to the original Constitution, the Supreme Court was to be the only federal court. Article 3, Section 1 of the Constitution begins by saying the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The Judiciary Acts of 1789 sets up the system of lower federal courts, as initially the Constitution only sets out the provision for the Supreme Court. It also sets out the role of the Supreme Court judges, who shall hold their office for life and in good behaviour. The Constitution does not make it clear on how many Supreme Court justices there should be, and nor is there any mention of judicial activism. We are going to start by looking at the structure of federal courts. As the Supreme Court is the highest court in the US and the final court of appeal, it is important to first look at the definition. Appeal means to apply to a higher court to reverse the decision of a lower court. Unlike in a criminal trial, the Supreme Court does not concern itself with the facts of the case, nor does it concern itself with the guilt or innocence of either party. Instead, it focuses on cases that are of constitutional importance. Its job is to decide what the Constitution really means in relation to these cases. However, before a case can reach the Supreme Court, it has to go through several steps first. Cases are first heard in state or local trial courts. There is at least one in every state. This is not part of the federal court system, so it is often not included in the hierarchy. The first step in the federal court system are the district courts. There are 94 district courts as the country is split into 94 judicial districts. There are approximately 663 judges. This is where witnesses are heard and a judge or jury decides whether the accused is guilty or innocent. 95% of federal cases begin in district courts. The judgment made by a district court can then be appealed in the US Court of Appeals, which is also known as circuit courts. Appeal courts do not try cases again and there is no jury. Instead, the judges review the decision made in the trial to make sure that the law was applied correctly. They may overrule the decision of the federal district court if they choose to. If you are unhappy with the result of the appeal court, you then can appeal to the United States Supreme Court. Confusingly, there are also state Supreme Courts, which also refer to cases that the US Supreme Court is looking at, such as constitutional issues or foreign affairs. So it looks like the Supreme Court deals with the cases that have been passed on to it from the lower courts. This is called appellate jurisdiction. However, there are times when a case goes straight to the Supreme Court, and this is called original jurisdiction, such as when cases between two states are involved, or cases between the US and a state, or a case involving a foreign minister and an ambassador. Once you get to the Supreme Court, this is the final court of appeal. Only cases they believe that are of major constitutional significance can be heard here. The Supreme Court also chooses which cases it wants to hear. It doesn't hear all cases. There is no automatic right to have one's case heard, and the Supreme Court often rejects over 95% of cases. The Supreme Court has enormous power. It can consider laws passed by Congress or state legislators and rule on whether they are constitutional or not. It can also declare actions of the executive unconstitutional. This is the process of judicial review, but I will go into this in more depth later on. Supreme Court justices are nominated by the President and then confirmed by the Senate in a highly politicised and controversial process. It is a 5-step process. Pause the video here and test yourself by writing down the process before I go through it in the video. A vacancy often occurs through voluntary retirement, which is usually down to ill health, death, or impeachment. The House of Representatives must impeach the justice, and the Senate must try that justice. No one has been impeached. In 1968, Associate Justice Fortas resigned rather than being impeached for bribery and tax dodging. On average, there is an appointment process every 2 years. President Donald Trump got to make 3 appointments during his term. This is arguably his biggest legacy. So what happens when there is a vacancy in the Chief Justice position? It is a similar process to an Associate Justice position. They are appointed by the President and then confirmed by the Senate. There is no requirement that the Chief Justice must serve as an Associate Justice beforehand, but 5 out of 17 Chief Justices have served on the Supreme Court as Associate Justice prior to becoming Chief Justice. Next, the President's team initially draws up a list of possible nominees, taking into account suggestions from the President's political advisors, party and legal experts. There are a wide range of factors to consider when choosing a justice, including a candidate's judicial experience or legal knowledge, their professional standing and reputation, and their personal history and integrity. Presidents aim to appoint justices who will share their view of how the Constitution should be interpreted. So conservative presidents nominate conservative justices, and liberal presidents nominate liberal justices. Nominees must be confirmed by the Senate, so presidents need to be confident that their candidate will attract the necessary support from senators. Possible candidates are shortlisted and background checks by the White House lawyers and the FBI commence. Every aspect of the candidate's professional and personal life is considered, with the aim of uncovering something to use against them in the confirmation process. This becomes more and more intense as the process goes on, as next there is a very intense process of the Senate confirmation hearing. Finally, the President announces their nominee, which often results in a massive media attention and scrutiny. The next 2 stages are the Senate Judiciary Committee, which holds a confirmation hearing on the nominee, and then makes a recommendatory vote, and the nomination is debated on and voted on in the full Senate. A simple majority vote is required for confirmation, but I'm going to go through this in more detail on the next slide. The Judiciary Committee holds a hearing on the nomination. The nominee makes an opening statement and then answers questions from the committee members. The hearing can take several days, and the questioning can become politically partisan and very intense. After the hearing is completed, committee members are given 1 week to submit written follow-up questions to the nominee, who then submits written responses. Finally, the committee votes on the nomination. The committee can vote to send the nomination to the full Senate with a recommendation of either approval or rejection. The committee can also send the nomination to the full Senate without a recommendation. Their vote is only recommendatory. Although their vote is only recommendatory, it does often influence how the Senate will then vote later on. For example, in 1987, Robert Bork was defeated by the committee vote and then was defeated by the full Senate. In 1991, Clarence Thomas, the committee voted 7-7, and the Senate only confirmed by a majority of 4 votes. During this stage, candidates may feel the need to withdraw. Presidents may also halt proceedings if he thinks they may be an embarrassment on the floor from his nominee. This has happened 3 times recently. In 2005, Harriet Miers withdrew after Republicans, who she was from the same party as, questioned her ideological credentials. In 1987, Douglas Ginsburg withdrew after revelations that he had smoked marijuana. In 1991, Clarence Thomas did not withdraw, even though there were accusations of sexual harassment from a former work colleague. You will be expected to provide examples in your exam of the nomination process. The controversial nominations of Merrick Garland and Amy Coney Barrett are good ones to know really well. I'm going to go through these 2 case studies. Let's start with Merrick Garland. Barack Obama nominated Merrick Garland to the court in March 2016. Republicans held the Senate, and they declared that they would not consider Garland as there was a presidential election due in November. Democrats were furious, arguing that such an action was unprecedented and that the Senate should begin hearings as the president had a right to nominate whoever he chose. Now let's look at the case study of Amy Coney Barrett. 4 years later, a vacancy on the court arose again, and again this was during an election year. Following Ruth Bader Ginsburg's death in late September 2020, Trump nominated Amy Coney Barrett to the Supreme Court. Despite the presidential election being just weeks away, Republicans were eager to take advantage of their Senate majority and confirm Barrett quickly. More controversially, Trump made it clear that he wanted Barrett confirmed and on the court before the election so that she could potentially rule in his favour if he chose to appeal the election result to the Supreme Court. In the event the Supreme Court refused to hear cases regarding the 2020 election results. Barrett is known for being anti-abortion, and there has been many fears that the Republican-heavy Supreme Court could vote to overturn Roe v. Wade. A quick note on where a president can recruit a justice from. There is the Federal Courts of Appeal, which is one tier below the Supreme Court, and they hear cases before the Supreme Court. All current justices have come from here except for Elena Kagan and Kavanaugh. They can also come from state courts, such as Sandra Day O'Connor, who was nominated by President Reagan in 1981. They can be a current holder of an executive role with vast legal experience. For example, President Nixon nominated William Rehnquist in 1971, who came from the Justice Department. Elena Kagan was Solicitor General at the Department of Justice, and she was nominated by Obama in 2010. Congress members or governors can also be nominated if they have suitable experience. Senate Majority Leader George Mitchell was seen as a potential nominee during the Clinton administration. President Eisenhower recruited Earl Warren, who used to be Governor of California, and he was Chief Justice from 1953 to 1969. The final place that presidents can recruit their justices from is from academia. For example, President Reagan nominated Harvard law professor Douglas Ginsburg, although he did later withdraw. Why do you think the Supreme Court nominations are so important to presidents? Pause the video here and have a go at answering this question. They are important for many reasons, one being that they are infrequent. On average, there has been one every 2 years. However, this isn't always the case. For example, there were no appointments at all between 1994 and 2005. It's also important because appointments are for life. When George W. Bush nominated John Roberts, he was 50 years old, and it's possible that he could be there for another 25 years. There are only 9 members, so one nomination is a huge proportion of the members. This is hugely important. The court also has the power of judicial review. It has profound implications for all Americans, ruling on issues such as abortion, gun control, freedom of speech, and affirmative action, which is the improvement of opportunities for marginalized groups. For these reasons, a Supreme Court nomination is hugely important to a president. What do you think is the selection and appointment process of the Supreme Court justices, and is it fit for purpose? This would be a good 9-mark question, so let's consider it. Pause the video here and fill out the table below with arguments for the selection and appointment process and arguments against. Let's go through some of these arguments, starting with the arguments for the process. Arguments that suggest that the selection process is fit for purpose are the fact that it is a detailed scrutiny of every nominee. This means that any past demeanours or controversial decisions are almost always uncovered. There are several opportunities for unsuitable candidates to withdraw from the process, so you aren't hiring someone who isn't fit for the role. The Senate Judiciary Committee members are expert in judicial matters, and they undertake detailed scrutiny of the candidates. Now let's look at arguments against the appointment process. Presidents choose nominees who appear to support their political philosophy. This can be dangerous. Justices may also be selected for their record on certain issues, such as abortion, as opposed to their judicial excellence. Questioning by the Senate Judiciary Committee can also be very aggressive and focused on embarrassing the nominee rather than trying to figure out whether they have good judicial expertise.